Hello everyone, I'm Ankit and you're watching StudyIQ IAS English. In our today's video, we are going to talk about a case, a judgment of which was given by Supreme Court of India and it changed India's history. Yes, you heard me right. This case literally changed India's history. So what was this case all about? What was the judgment given by the Supreme Court in this case? And what were the events that transpired after this judgment that changed India's history? We are going to find that one out in our today's video. Now, this topic is very important from your UPSC perspective also because it deals with matters relating to fundamental right that is given in the part 3 of the Constitution. Therefore, you should download the notes which is available in the Telegram channel ATS Live. And while you're at it downloading the notes, please do not forget to subscribe to the channel also. Okay, so let us start our today's discussion and let me give you a context so as to why I am taking this topic in the year 2025. Now, if you remember, a Bollywood movie is coming called as Haq, which is going to be released tomorrow, that is November the 7th. And the subject matter or the story of this movie is inspired from the events that happened in 1985 Supreme Court judgment given in the Shah Bano case. So what was this case all about? What was the judgment given by the Supreme Court in this regard? That we are going to find out. But let me give you a brief background of this issue. Now, this case relates to a 62-year-old Muslim woman who was divorced from her husband, Shah Bano Begum, who was a resident of Indore. Now, in the judgment given by the Supreme Court, it raised national debate on certain important facts. First fact that was raised after the judgment given by Supreme Court, whether India is a secular country or not, or whether India indeed provides minority rights to the minority communities in India. And the larger question that it raised, whether India needed a uniform civil code or not, which is a code applicable to all Indian citizens irrespective of their religion in personal matters. Now, if you remember, this Uniform Civil Code is provided in Article 44 of the Indian Constitution, which is the provision relating to directive principles of state policy. And this gives it on the discretion of the government whether or when to enact this Uniform Civil Code. Right? So this was the issues that this case raised. So let us now discuss what this case was all about. What were the factors that led to filing of this case in the Supreme Court of India? Now, as I told you, in the year 1978, a resident of Indore, Mrs. Shah Bano Begum, she got divorced from her husband, who was a notable lawyer in the region, Muhammad Ahmad Khan. And they got divorced after 43 years of successful marriage. Now, after her divorce, her ex-husband paid herself some money, which was a maintenance to support herself financially for a certain period, but after that it was stopped. So naturally, when she was unable to maintain herself financially, she went to court demanding her rightful honor, that was the maintenance that should be paid by the ex-husband. Now, she used this provision given one under the section 125 of the CRPC Act 1973, which obligates a person who has sufficient financial means to provide maintenance to people who is responsible on them, right? So that means that this person who is financially sufficient should provide maintenance to all people who are depending on him, including his wife. Now, the word wife here has wider meaning. It also includes ex-wife who has been divorced by the person, right? And this ex-wife, until she gets remarried, should be supported financially by her ex-husband in case if they were dependent on the husband in the time of marriage. So this was the power given to Mrs. Shah Bano Begum under the CRPC Act, and using this power, she claimed maintenance from her ex-husband. So this was the case. Now, naturally, her ex-husband contested this petition, saying that the only financial obligation he had towards his ex-wife was for a fixed period of iddat. Now, under the Muslim personal law, a husband should provide financial maintenance to his ex-wife for a period of iddat, which is the 3 months after the end of marriage. And in this time of iddat, the ex-wife is not supposed to remarry. And so, the defendant or her ex-husband said that his only obligation to provide financial maintenance to his ex-wife was for a period of 3 months from the end of marriage, that is the period of iddat. And he said that he not just paid her the maintenance money, but he also paid her the money which she rightfully agreed on meher, which was the right of wife from her marriage. So the defendant claimed that he paid the money for her maintenance and he paid the money for meher. Therefore, he had no further physical obligation towards the women. So this was the defense position held by the ex-husband. Now, hearing this matter, a local court directed the ex-husband to pay a nominal amount of rupees 25 per month to his ex-wife, that was Mrs. Shah Bano Begum. And this case was subsequently challenged in the Madhya Pradesh High Court, which increased the amount of money that the ex-husband should pay to an amount of 179.2 rupees per month. So naturally, Khan went against this decision to decide to appeal this matter in the apex court of our country. Right? Now, what happened in the apex court of country? This matter was heard by a constitution bench, which consisted of 5 judges, and it also included at that time the Chief Justice of India, Mr. Y.V. Chandrachud, who is also the father of former Chief Justice of India, Justice D.Y. Chandrachud. Now, these bench of 5 judges, they delivered a verdict and they dismissed the appeal which was filed by the ex-husband, and at that time they upheld the decision of the High Court of Madhya Pradesh. They said that yes, it is the responsibility of the ex-husband to support his ex-wife financially by paying the amount that the High Court of Madhya Pradesh directed, that was the rupees of 179.20 per month to his ex-wife. Now, this court also gave an interpretation on the section 125 of the CRPC Act. It stated that this provision, which was enacted to prevent destitution of the people who were depending on the person up till marriage, this is a secular provision, which means this is applicable to all citizens of India irrespective of their religion. So there is no reason, there is no excuse so as to why you should exclude a Muslim woman from the ambit of this particular act. Therefore, Supreme Court of India, in its judgment, it concluded that a divorced Muslim woman, if she is unable to maintain herself financially, she is entitled to claim maintenance from her ex-husband even after the end of the Iddat period. As I told you, Iddat period is the period of 3 months after the end of marriage, and at that time, a Muslim woman can't remarry. So the Supreme Court of India said that Muslim woman, if she is unable to maintain herself financially, she would continue to get maintenance from her ex-husband even after the end of Iddat period. Now, this judgment or this bench ruled while deciding on the matter whether this section 125 of the CRPC Act, whether it was in conflict with the Muslim personal law, right? I told you Muslim personal law said that the only obligation of the ex-husband was for the period of Iddat. But Supreme Court gave an interpretation of section 125 saying that the ex-husband should pay financially to the woman who is depending on him even after the end of the Iddat period. Now, while highlighting this balance, the Supreme Court referred to the holy text of Quran. It stated that this holy text of Quran imposed an obligation on the Muslim husband to provide for his divorced wife. So this was the interpretation given by the Supreme Court of India. And while doing so, Supreme Court highlighted one important thing. Had government at that time would have implemented the Uniform Civil Code given under Article 44 of the Indian Constitution, then this would have been not a problem. But otherwise, since DPSP, since Article 44 remained a dead letter, therefore this case arised on the first hand, right? So this was the judgment given by Supreme Court. Now, naturally, this judgment was not well received by many sections of Muslim community, particularly by the All India Muslim Personal Law Board. This organization saw this judgment of Supreme Court as an encroachment of minority right. It saw this as an encroachment on Muslim personal law. Therefore, to counter this judgment, All India Muslim Personal Law Board organized a large-scale protest against the verdict in order to pressurize the then government. Now, if you remember, in the year 1985-86, India at that time was ruled by a Congress government who received a very big majority of more than 400 seats in the last Lok Sabha elections, which happened in 1984. But even after the creation, or even after having this huge majority in the parliament, the government got pressurized by the Muslim sections of society, and therefore, to nullify the judgment given by Supreme Court in the Shah Bano case, the government at that time passed the Muslim Women Protection of Rights on Divorce Act 1986. Now, there were many political fallouts after the enactment of this act. One political fallout included the then resignation of the law minister Arif Muhammad Khan, who is the present governor of the state of Bihar. So he was against this law, so he resigned from office as the law minister of India. Now, this law, it stipulated that a divorced woman was entitled to a reasonable and a fair provision of maintenance only during the period of Iddat. And after this period, if the woman is unable to maintain herself financially, then the responsibility would not fall on the ex-husband. Rather, it would fall on her relatives. And if relatives is unable to maintain the woman, then the responsibility would be taken care of by the Waqf board of the state. So in any case, according to this law, the ex-husband would not be responsible for maintaining his ex-wife financially after the end of iddat or after the end of 3 months from the divorce. So this was the law which was passed in the Indian Parliament by the then majority government led by Congress. Now, naturally, this law created a lot of political controversy for the government. I told you one controversy was the resignation of then law minister. The second controversy was that many Hindu right-wing groups, they accused the government of that day that they were appeasing the sections of Muslim, and they went against the judgment of Supreme Court. So as to satiate the demands of Hindu right-wing group, the government did one very big mistake. It opened the gates of Babri Masjid in Uttar Pradesh and it unlocked, and this was very surprising because this gates in Babri Masjid, which was located in Ayodhya at that time, was unlocked by a Congress-led government in Uttar Pradesh. Now, this case proved to be a pivotal movement in Indian history because after the end of the case, when Muslims protested, the government tried to mollify them by bringing a law, and to mollify the people who were criticizing the law, the government opened the gates of Babri Masjid, and all of this led to a domino effect which culminated with the event of demolition of Babri Masjid in the year 1992. And this fundamentally shifted the track of Indian politics. Now, when BJP is in power, one of the key reasons why they became politically strong was because of the Rath Yatra, which followed the demolition of the Babri Masjid. So this was reason why it changed India's politics. Now let us come back to our discussion of the new law. I told you this law was brought by the Congress government, and naturally, the constitutional validity of this law was questioned in the Supreme Court of India by none other than the former lawyer or who represented Shah Bano in the Supreme Court. Now, this case was given to a Supreme Court Constitution bench in the year 2001, and the court upheld this act, but it did so while interpreting some of the provisions of this act somewhat creatively. So what was the creative interpretation of the Supreme Court to protect the rights of women from this act? Let us discuss that. Now, the Supreme Court focused on a particular section of this act which required the husband or ex-husband in this matter to pay or financially maintain his ex-wife with a reasonable and a fair provision of maintenance which should be paid during an iddat period. Now, the court, that is the Supreme Court, interpreted this that the husband's liability was not just limited to iddat period. Yes, the husband would make the payment in the iddat period, but this payment should be sufficient enough to maintain the woman even after the end of iddat period if she decides not to remarry, or if she is unable to support herself financially. So according to this creative interpretation of the Supreme Court, this husband needs to make a one-time payment during the iddat period, but this payment should be large enough to provide for the maintenance of the ex-wife for the rest of her life or until the time she decides to remarry. So this was the creative interpretation given by the Supreme Court, which effectively upheld the provisions of the Supreme Court judgment given in the Shah Bano case. But this judgment also left a degree of ambiguity. This ambiguity that from after this judgment, if a Muslim woman decides to end her marriage, so under which provision she would demand for her maintenance? Would she use 1986 Act, which was passed by the government, or she would use Section 125 of the CRPC Act? So this was one of the ambiguity that was left out. Now, thankfully, this ambiguity was addressed last year in the case of, in the case of Muhammad Abdul Samad versus State of Telangana. Now, in this judgment, the Supreme Court ruled that the 1986 Act, it does not bar a divorced Muslim woman from seeking maintenance under the Section 125 of CRPC Act. The Supreme Court in this case said that the 1986 Act, it provides a remedy in addition, not against the remedy provided under CRPC. So it clarified that if a Muslim woman gets divorced, it is her choice whether she wants maintenance under 1986 Act, whether she wants maintenance under 125 Act, Section 125 of CRPC, or both of them. So the choice lies with women, right? So this was how the Supreme Court cleared the ambiguity in this case. Now, before solving a practice question, which I've curated exactly on the patterns of UPSC, let me tell you one very important thing. Now, this matter which I picked up was relating to a very specific part of fundamental rights and DPSP. If you want to know entirely about polity, you can subscribe to the classes that are in P2I foundation batches. Now we are offering P2I foundation batches not just for polity, but all the subjects which are important for UPSC exam will be covered here. In addition to that, you get mock test for both prelims and mains. You get one-to-one mentorship support, interview guidance program. All of this is benefit which is available to students who enroll themselves in the resolution P2I foundation batches. The word P2I means everything from prelims to mains to interview. Everything is covered as far as GS and CSAT is concerned. So you can take admission either in 2027 or in 2028 cases. But if you use the code ATS Live, you'll get maximum discounts. Discounts up to 7,000 rupees. So please do not forget to use this code and save a lot of money. Now let us come back to this question. I'd want each and every one of you to solve this question. The idea of Uniform Civil Code aims to replace personal laws based on the scriptures and customs of each major religious community in India with a common set governing every citizen. So which one of the following Constitution of India correctly and appropriately implies the above statement? Please do let me know which is the correct answer among all these 4 options in the comment section. And the ones who answer it correctly would get a thumbs up from my side, okay? And once again, if you want to download the notes, this is where it will be available on the Telegram channel ATS Live. So we'll see each other again. Please have a very good night.